That noisy crowd in the back over there, if you could please take your seats. And if people could move up closer so the front seats are filled. For those who are interested, by the way, C-SPAN will be airing this program on Monday, this coming Monday. We don't know what time yet, but for those of you who are interested, this program will be aired on C-SPAN, we're told, in 2 days. And if you check your listings, I'm sure you'll find the right time and station. It really is a pleasure for me to introduce our final keynote speaker. And I guess it's clear to me that this is one of those individuals where there may, in fact, be a generation gap. And the good news is that that generation gap is soon to be overcome, because in a very short time, Denzel Washington will be playing Rubin "Hurricane" Carter in a Norman Jewison film. Rod Steiger will be playing the federal judge who I'm about to refer to. And I think people of the younger generation will certainly come to know Rubin "Hurricane" Carter. I guess for me, when I was growing up, I knew of Rubin, knew of Hurricane, because he was the #1 contender for the middleweight boxing champion of the world. And in those days, I used to watch boxing matches, and I was just incredibly impressed with this individual's skills in the boxing ring. And I remember several fights quite clearly, even today, in which Rubin knocked out the then champion Emil Griffith in 69 seconds of the first round. He was clearly a force, and a powerful force, and he remains that way today, although he's taken on a different fight, a different battle. And when I was a college student, it was then in 1966 that we heard about the police charging Rubin Carter and John Artis, who's also present here today, with the most serious crimes of having committed murder against, I believe, 2 white people, 3 white people. And I couldn't believe it then. And I continued not to believe it as a law student at Rutgers Law School. The crime itself occurred in New Jersey, so many of us became involved in Rubin's case. Unfortunately, it took 19 years before a federal judge agreed and dismissed the conviction against Rubin "Hurricane" Carter. It was 19 years of his being incarcerated, and the judge in that decision said that Hurricane's conviction had been based, quote, on racism rather than reason, and concealment rather than disclosure, and that Rubin "Hurricane" Carter's imprisonment had been a quote-unquote travesty. Today, Rubin "Hurricane" Carter lives with his family in Toronto, Canada. He is the executive director of the Association in Defense of the Wrongly Convicted here in the United States, in Rubin's home country of Canada, and in England. And it's a great pleasure for me to introduce and welcome Rubin "Hurricane" Carter.
Thank you, Doc. Thank you very much. Good afternoon, everybody. Ladies and gentlemen, Professor Doug Colbert, Stephen Bright, honored guests, and friends. It is truly, truly a great honor and privilege for me to be here at the University of Maryland today. But when you come to think about it, given my history, it's a great pleasure for me to be anywhere today. And I know that some people may be disappointed that Brian Stevenson is not here. Brian couldn't make it for some reason, and so they called in the second string. And I hope you don't be disappointed. But he who bemoans the lack of opportunity forgets that small doors often opens up into large rooms. So I want to take a moment here and pause. For whom told? They told for thee, my friend, my brother, my love. I bow to you, and I respect and accept everything that you stand for, truth and righteousness. Ladies and gentlemen, we have in the audience with us this afternoon the one and only person, the one and only absolute reason why I am standing here today, alive and well, other than the creator, of course. John Artis, for 20 years, literally had the outcome of my life in the palm of his hand to do with whatever he chose to do with it. And I had no choice in the matter whatsoever. Only John and the creator, they were calling the shots, and I was simply a puppet. My life was not my own. It belonged to John Artis. My innocence belonged to John Artis. You know what a shutska is? Does anybody know what a shutska is? Shutska is Russian for stool pigeon. John Artis is not a stool pigeon. If he was, I would have been dead 33 years ago. In every case of wrongful convictions that I've come across, a stool pigeon is always the main element of that atrocity. A jailhouse stool pigeon, a jailhouse snitch trying to buy their way out of jail or simply trying to get some money without sticking a gun to somebody's head. Wouldn't you agree with me, Stephen, that stool pigeons are the most central ingredient to all wrongful convictions? All John had to do was to say that Rubin Hurricane Carter, that bald-headed, loud-mouthed prize fighter who hated everybody, including himself, killed those people. And I would have been dead. And John would have been free and alive to carry out his life as he intended. You see, I didn't know John Artis, and John Artis didn't know me when we were convicted of this crime. I was 29 years old, and John was 19 years old. We didn't hang out together or anything like that. John was a church-going young boy. John had just graduated from high school and was on athletic scholarship to go to college. John was one of the best track people in the United States at that time. John never had any problems with the police ever before. Didn't know anything about the police. Me, I was that loudmouth prize fighter on television every week, getting my brains beat out or knocking somebody else's brains out, saying about what was going on in the United States at that time, where people of African descent were segregated, where people of African descent was riding on the back of buses, where people of African descent couldn't drink out of this water fountain or couldn't go to that school or couldn't live in this neighborhood. Yes, the government wanted me because I was saying, protect yourself. Do not allow anybody to hurt you. Even if they were wearing a blue uniform, they're still a criminal. Still a criminal. And John Artis would have had a great life ahead of him. But he didn't do that. He didn't snitch. Every time someone asked John to make a deal. John responded by saying, my mother and father didn't teach me to lie. They taught me to tell the truth. When the government itself, the government of New Jersey, went down to prison and took John Artis out of prison and brought him home to Paterson, New Jersey, and sat him down in front of his mother and father and told him and promised them, and this is 6 weeks before Christmas, that if John would give an incriminating statement that in any way inculpated me with this crime, that the governor of New Jersey would guarantee that John Artis would be home for good before Christmas. Now, that's what the whole deal was all about, lying. And John wouldn't do it. That's miraculous. Sitting in jail for 15 years, where everybody all around him was giving up and giving out and giving over, John Artis had the courage, the integrity, the tenacity, the honesty, and the fortitude to just say no. My mother and father didn't teach me to lie. But you know what John told me in private while we were walking around the prison yard one day? John said, Rubin, if I thought that you really had something to do with murdering those people, he said, I would have told the police, because I wouldn't lie for you either. I wouldn't lie for you. Now, that's the truth. That's John Artis. And I am tickled pink that it was you who got busted with me and not somebody else who would have made a deal. John is my chosen angel, chosen by the Creator. I don't think there is another human being on this planet who could have withstood the tremendous horrors that we faced in prison together. The degradation, the humiliation, the rampant violence, and not become a shitska, not become a stool pigeon. And for that alone, John, I cherish you and will forever be in your debt for maintaining strength enough, courage enough, fortitude enough, honesty enough, and all those other good things to go the distance. Ladies and gentlemen, I would like to introduce to you my hero. And so that you may see what a real hero looks like and never be fooled again. Ladies and gentlemen, my hero and his lovely wife, Mr. and Ms. John Artis. John, please stand up for me. You too, darling. Darling, stand up. Thank you. Okay, you can sit down now. God, can't take those guys anywhere. You know what I mean? They always try to steal your thunder. As I said, the only reason why I'm here today is because of John. Thank you, sir. Thank you. But there is also another reason why I'm here today. If it hadn't been for a quaint Latin phrase, habeas corpus, I'm afraid I would have been a no-show here today due to a prior commitment. You see, the state of New Jersey had me booked for something else. In 1966, at the age of 29, I was at the peak of my career, a professional prize fighter about to fight for the championship of the world. And the next thing I knew, we were fighting for our very lives, on trial in criminal court. We were accused of murdering 3 people in a New Jersey bar. The state sought the death penalty. We were facing the electric chair for a crime that we did not commit. The odds of our being alive today were not exactly in our favor. There were 3 murder victims. All of them were white. The jury was all white. The judge, the police, the state's witnesses, and the prosecutors were all white. We, at that time, was black. But luckily, if you can call the hell of a triple life sentence luck, because I was a somewhat successful prosecutor and had the money to pay for first-rate lawyers, we escaped execution. But it was the quality of our legal representation that made the critical difference. It allowed us to remain alive. Now, when Professor Colbert asked me to substitute for Brian Stevenson and speak to you tonight about Gideon versus Wainwright and the right to counsel, I sort of worried about that. I really did. Because it is absolutely impossible to speak about the right to counsel without speaking first about habeas corpus, politics, popular culture, and fear. A big topic for so little time. I recently heard someone say that the law is just politics by other means. Now, that's a rather cynical view of justice. But what's driving the current push to clamp down on habeas corpus, if not politics? And what drives the politics, if not fear? Now, we'll get back to this question of fear in a moment. But first, let's deal with some myths of popular culture. People say and believe, professionals and lay people alike, that there are certain absolutes that will keep you from being sent to prison. Certain absolutes that will keep you from being sent to prison. First of all, don't commit a crime. Now that's absolute, and we all believe in that, right? Speak to me, right? Sure we do. Second, tell the truth. If you've done nothing wrong, you've got nothing to hide, right? Right. Okay. Third, if you are accused of a crime, get a good lawyer. 4, have a solid alibi supported by credible witnesses. 6, pass a lie detector test. 7, if you don't have the motive, the means, or the opportunity to commit the crime in question, you're home free. Right? Wrong. We didn't have a motive, we didn't have the means, and we didn't have the opportunity. And even though we did not remotely fit the descriptions of the assailants, even though the 2 surviving victims did not and could not identify us and even said it was not us, even though we had a number of alibi witnesses placing us elsewhere at the time of the crime, even though we passed lie detector tests showing that we had no involvement, and even though we had nothing to hide, testified voluntarily before the grand jury and was exonerated, we were still convicted. So what the hell happened? What happened? Well, as cynical as it may sound, as cynical as it may be, politics reared its ugly head. The prosecution, the state, is out to win. Winning is how careers are advanced. Successful police officers are promoted. Successful prosecuting attorneys become judges. And a successful judge is one who is seldom reversed on appeal. Discovery rules notwithstanding, the state is not going to tell you what they don't want you to know. And so you are going to have to go out and find it for yourselves. Let me give you an example from our case. There was no motive offered at our first trial in 1967. No one, not a living soul, had any kind of explanation as to why John Artis and this Rubin Hurricane Carter would do such a thing. Nobody, no motive. But after the recantation of the state's two key schutzkas, witnesses, themselves suspects in the crime, in order to rehabilitate their case at our second trial 9 years later, the prosecution suddenly conjured up a motive: racial hatred, racial revenge. The prosecutor said that me, my co-defendant, and I committed this crime because we hated white people. We invaded a white neighborhood and picked that bar in particular because the bartender was a known racist who refused to serve black people. The bar, the prosecutor proffered, was therefore a natural target for racial revenge. That's what the prosecution proffered, and that's what the jury heard. Now, in our own investigation, we discovered witnesses known to the police, a black couple who had been served by that same bartender that very night, and even had a running account with him. We went on to discover that the bar in question was actually in a mixed neighborhood, and that the bartender was, in fact, friendly to black people. But there is the distortion and manipulation. The prosecutors start with a fact that the victims were white and the assailants black. And then they begin to concoct an elaborate fiction that plays right into the jury's worst fears: Armageddon, race riots. It's akin to Commonwealth versus Stevens. You must have heard about that case. There's the fact of a cop killed in uniform. From that, a tale is spun. The tale of a saintly veteran father figure being cut down in the line of duty, looking out for young wayward girls. When in fact, as the defense's investigation revealed, that cop was actually selling those girls. He was a pimp, an extortionist, and a drug abuser. Why, if he weren't a cop himself, the cops would have been out there looking for his butt. Now, in the face of all this, what do you as lawyers do? How do you keep us alive? Or at least, how do you keep us out of jail? Well, you don't do it by being a defense lawyer. You have to be an offensive lawyer, even if it offends the powers that be, because that's your job. And if offending the powers that be in any way disturbs or distresses you in any manner whatsoever, then putting it to you very mildly, perhaps you better find a different occupation. because lawyering is not stress-free. Now, I'm sure that some of you, or at least maybe all of you, are familiar with the late, great Edward Bennett Williams. He was a giant in the legal field. He was what we called a pawnbroker. Every president was his client. Now, I had the good fortune to know Mr. Williams before my incarceration in 1966. Mr. Williams had tried to recruit me to play football for the Washington Redskins for $25,000 a year. That was good money. You know, join his squad of 11 for $25,000 a year. That was still good money. But you see, I was already making over $100,000 a year by myself. And so I said to Mr. Williams, I said, man, you must be crazy. You can get hurt playing football. Yeah. I'll stick to a kinder, gentler occupation. I'll stick to boxing. Throughout my 22-year legal nightmare, Mr. Williams, while not on our legal team per se, never hesitated to give us advice whenever we asked for it. And he gave it pro bono. The best time to get him was always 8:30 in the morning. His secretary would promptly put my call through, and Mr. Williams would always take the time to answer any and all of my questions, which indeed were very many. But that kind of access, that kind of care, and that kind of attention means more to a prisoner than you can possibly imagine. And that in spades is the whole raison d'etre of a lawyer, to provide legal access, care, and attention to those you represent, and especially to those who find themselves on the bottom of the empowerment pile with nowhere else to turn. Now, you see, I'm on the board of directors of the Southern Center for Human Rights in Atlanta, Georgia. And we deal with death penalty cases in the South on a daily basis, as Stephen no doubt has told you. I'm also on the board of directors of the Alliance for Prison Justice in Boston. And we deal with medical and brutality in the prison system because I lost my eye for the lack of basic medical attention while I was in prison. John contracted an incurable circulatory disease where John's fingers and toes are being amputated daily. Nobody ever leaves prison unscathed. And I'm also the executive director of the Association in Defense of the Wrongly Convicted, based in Canada, Great Britain, and in the United States. Now, you see, I say that not to toot my own horn, because my horn doesn't toot, but simply to make a point. The director of the Southern Center for Human Rights, Stephen Bright, and there he is sitting right here, a young, white Southern boy. Brilliant, brilliant, absolutely brilliant, and with a beautiful heart. Stephen once told me, he said, Rubin, only one heart can teach another heart what the written word doesn't say. And Stephen's heart has been teaching my heart ever since. I love you, Stephen. Now, Stephen Bright is a great lawyer because Stephen doesn't hide his outrage. He allows himself to be outraged, and he isn't complacent about it either. The first thing that Stephen and his colleagues at the Southern Center do when representing a black defendant in the South, is to make an immediate motion to have the Confederate flag removed from the courtroom. Get out of here. Get out of here. That Confederate flag is a symbol to Brown versus Board of Education. It is a defiant cry that we will not educate all of our citizens. Now, and even if the motion is denied, as it so often is, Stephen and his colleagues have sent out a strong message that this is not going to be business as usual. And anything less than equal justice will not be tolerated and will be vigorously opposed. You don't have to look far to find plenty to be outraged about. This country, which considers itself the leader of the free world, is the only Western industrialized nation that insists upon maintaining the anachronism of the death penalty. And we don't even deny its racist application. Hell, we even kill children and mentally retarded adults. It's not hard to be outraged when you realize that in no other country would this topic even be necessary. This specialty of law doesn't exist elsewhere. It's not hard to be outraged when you hear that lawyers in Louisiana and Mississippi representing indigent cases received a ridiculous sum of $1,000. And that's the maximum. No matter how intensive the investigation, the preparation, or the trial. And in Georgia, the fee is even less. And as I learned last night, for juvenile defenders in the state of Virginia, lawyers are only given $200. It's not hard to be outraged. When you look at the crazy politics of electing judges and district attorneys whose sole livelihoods depend upon satisfying a vengeful but poorly informed electorate, it's not hard to be outraged. So get outraged and wear your outrage proudly. Let it show to your client, to your adversary, to your students, to the judge. It'll make a hell of a difference in their attitude. They'll respect you for that. They may not like it, but they'll respect you for it. There's nothing more self-defeating and more disheartening to a client than a tired, cynical, timid lawyer just going through the motion. You need outrage. It'll make you a more effective lawyer. It would catapult you up to the very same level as a Stephen Bray. And it'll give you the energy, the strength, and the courage you're going to need to persevere. The right kind of attitude always produces the right kind of action. The first thing you have to do is to make a connection with your client. Make sure, even if it's in your own mind, that you are not dehumanizing your client either. Because let me tell you exactly what your client feels like while being on trial in a capital case, or in any case for that matter. Your client feels like he's contaminated, as if he has some vile disease that must be eliminated before it affects others. He feels like a non-person, like a thing. He feels like an object that everyone is staring at, talking about, and arguing over, but never addressing him directly. Your client does not understand the process. He doesn't understand what's going on. He doesn't understand the process. He doesn't understand what's admissible and what isn't admissible, and why it isn't admissible. He doesn't understand why this question is asked and not that one. Your client doesn't understand the language. Everybody in the courtroom is speaking legalese. and he doesn't speak it. He doesn't understand the people, because the people come from another world. So he trusts no one, including you. The only thing your client does understand is that his life hangs in the balance and there's nothing that he can do about it. Your client feels helpless, powerless to do anything or to say anything, all with the dread of violent death coming closer and closer as this terrifying ritual plays itself out. Because that's what going to prison means, death. Prison is the lowest level of existence that a human being can exist on without being dead. That's how diabolical prison really is. So open up the lines of communications to your client. Don't hold it against your client if they're defensive, skeptical, or evasive. Because more often than not, your client has already been abused by the system. And so you are going to have to prove to him or to her that you're not there simply to continue that abuse. Now, the next thing you have to do, please, you must do this. Refuse to accept the prosecution's case on face value. And don't be satisfied with merely rebutting it, because you owe it to yourself and to your client to conduct your own investigation. An investigation independent of the prosecution and independent of the police. And I guarantee you, in every case, you're going to find something useful. And even if your investigation convinces you that there's no chance of success at trial, explain that to your client and to his family. Do everything you can to avoid going to trial and save your client's life. There will always be something in your investigation that will make a difference. And that's whether it goes to guilt, to the charge, or to the sentences. But as you well know, this evidence must be uncovered before trial, because appellate routes are being severely restricted. Access to the writ of habeas corpus is being limited not only by the United States Supreme Court, but by Congress and the President. The writ of habeas corpus, the federal check on abuses at state court levels, the one life-affirming jewel in the crown of thorns we know as the criminal justice system, is being threatened with extinction. And that's just one more thing to get outraged about. This, and I carry it with me everywhere I go, the writ of habeas corpus is not just a piece of paper, not just a quaint Latin phrase. This was the key to my freedom. The key that other innocent people like Roger Coleman in Virginia and Leonel Herrera in Texas didn't have. And now they are both dead. This, the writ of habeas corpus, is the only thing that rescued me from dying in prison. This simple piece of paper, these few words, it is ordered that the petition of Rubin Carter for writ of habeas corpus hereby is granted. These few words gave me back my life and gave precious hope to so many others. The great writ, ladies and gentlemen, is indeed something tangible. It is not abstract. It is the concrete right of every man, woman, and child in this country. It is our birthright to be free from arbitrary, capricious, unjust, unconstitutional judgment, confinement, or execution. And now there are forces at work trying to limit our access to it even further than they already have. Why don't we realize that by taking away our access to habeas corpus, we're being robbed of something as real as money and far more valuable? Why aren't the burglar alarms sounding? And where are the cops when you really need them? Oh, that's right. They're down there in Washington with Monica Lewinsky, aren't they? When back here, our freedom account is being looted. You, as lawyers, have an awesome responsibility. And that's whether your client is innocent or guilty. You can't afford to make a mistake. Your client can't afford for you to make a mistake because the penalty for them is just too high. Criminal cases, and especially capital cases, are not for the faint of heart. We just heard everybody talking about lawyers who are assigned to capital cases are being burnt out. Well, they are. I mean, I'm not trying to frighten you, but as they say on the street, this shit is real, homie. There's a rush to death in our society, a chilling climate of anti-crime hysteria and fear. And that's our real adversary here, fear. We can't turn on our TV sets or open up a newspaper without the specter of violent crime entering our living rooms, frightening us to death. You see, fear is really at the heart of everything. Fear feeds prejudices, inflames passions, but clouds one's judgment. When you fear someone, anything is possible. You can then justify anything, psychologically and legally, from slavery to segregation to anti-Semitism to the McCarthy witch hunt. You can justify the erosion of constitutional protection and justify the wholesale application of the death penalty against minorities, the poor, the disadvantaged, the disenfranchised. Blinded by our fear of crime, we focus only on the symptoms and completely ignore the causes, the roots of crime, the poverty, illiteracy, unemployment, drugs, and yes, racism. And instead of extending opportunities to people, we punish them further. Why, I can count on my thumb and my index finger the number of people from privileged backgrounds that I met during my 2 decades in the penitentiary. Zip. It's the people who are marginalized in our society who most need our help, because overwhelmingly, they are the ones that we so eagerly consign to our nation's prisons and death chambers, albeit under the color of law. So, what can we do about it? Well, we can't do anything if we let ourselves become overwhelmed, jaded, and cynical. You know, our attorneys, Myron Beldock, Professor Leon Friedman, and Lou Steele, all New Yorkers, took up our case after we had long since run out of money and labored on our behalf for over 10 years without any expectation of ever being financially compensated. Mr. Beldock's office alone booked in 11,000 man-hours, over $100,000 in out-of-pocket expenses, and millions of dollars more in unbilled legal fees. They did it, they say, because it was the right thing to do. And I'm glad they did it. They did it pro bono. And they are the first to proclaim how much richer they are for having done it. As Mr. Beldock likes to say, money is not the only currency. He also likes to say, and I guess this is a lawyer's joke, you'll be able to tell me that better when you hear it. He also likes to say that people make counterfeit money. But in many more instances, money makes counterfeit people. Now, I know there's no danger of monetary contamination happening when you are dealing with capital cases, as most of the capital cases involve indigent clients. So I commend you for earning some of that other currency, and I applaud you for your efforts, which all too often go unrecognized. More often than not, the law is studied only as an abstraction. And we forget that human lives are critically affected by laws, that human lives are literally at stake. Literally at stake. You have the power to make a difference. You can save lives. Is that important? The petition for Rubin Carter for writ of habeas corpus is hereby granted. You know, it's been almost 14 years now since the Honorable H. Lee Sarakin penned his big, bold, beautiful signature beneath these words. 14 years. I can still scarcely believe it. But without the tireless efforts and dedication of lawyers and aspiring lawyers like yourselves, I wouldn't have this document now. And I sure as hell wouldn't be here in Maryland with you today, alive and free. Is your work important? I defy anyone to tell me that it is. But then again, what does an old punch-drunk prize fighter like me know? What I do know, and I'm about ready to close, my brother.
Keep going, man.
What I do know is that in order to be successful, you're going to need courage. You're going to need strength. You're going to need sustenance. You're going to need energy to persevere to be successful. And therefore, John and I and Dolly would like to invite all of you out for dinner tonight. Treats on us. Treats on us. Because you and you and you and you are going to be the ingredients upon which we feast. First, we'll begin with our appetizer. Yeah. Which will be a long life, marinated in good health, but seasoned with moderate wealth and sauteed in a rich broth of very satisfying family life, with just a dash of rewarding progeny. Our main course will consist of a succulent roast of freedom and justice, bathed in a clear sauce of brotherhood, which has been carefully glazed and crystallized over an open fire of human dignity, stuffed with prosperity, and sprinkled with a generous serving of peace and goodwill, accompanied by a sparkling wine of love and friendship, drunken out of golden cups of higher consciousness. For only happiness can be the wine that sharpens the taste of the meal. And now, for pillage de résistance. I can't speak English. I'm trying to speak French. We will have a warm and loving gel of understanding, which can only be filled by the fruits of both knowledge and being, surrounded by the sweet syrup of goodness, which always comes from it. And this, my friends, will be topped off with a soothing after-dinner drink of good habits, laden with success. And of course, in order to enjoy the succulent morsel of success, we must also have a jigger of happiness. And laughter will be our handmaiden who serves us. Ladies and gentlemen, dinner is on the table. Let's get busy. Thank you. Do we want any questions or answers?
Rubin, we'll take any questions if anyone has any. I think this is probably a good time to break. I, of course, want to thank Rubin for his remarks, which I know we'll all remember for a long time, and in case we forget, we have it on tape so that you can watch it as often as you need to re-energize and recommit ourselves. I only want to say in closing that there's a lot of people to thank for this conference, and most of all, of course, I want to thank the Maryland School of Law for allowing us to put this forward. The Maryland Law Review students have been wonderful, particularly Joe Key. There is going to be a reception following this at a lunch reception. It'll be at my house. It's to honor Rubin and John. And if anyone is interested, panelists, of course, and guests are invited guests are welcome, and anyone else who would like to come should just see me so that I can just sort of take a count to make sure we have enough food for everyone. And I thank you all for coming, and I hope we'll be getting together again soon. Thank you very much.
The presidential campaign rally with Vice President Gore is next. Then Saturday's retirement announcement from Florida Republican Senator Connie Mack. At about 10:10 this morning, Rhode Island Republican Senator John